Hello and welcome to the Accountancy Age Big Question. Today we're talking about an issue of great importance for local councils, the provision of off-street parking and the VAT associated with it. I'm here with Mark Welby, the VAT partner at BDO Stoy Hayward. Hi, Mark.
Hi, Alex.
You led this case on behalf of the councils. Just tell us in a nutshell what it's about and what the recent ECJ judgment means.
Okay, well, the decision is, or the issue is really whether or not local authorities should charge VAT on the provision of off-street car parking. Because their main aim in providing parking is to regulate traffic flows and traffic movements, it's under a special legal regime, and to date the UK courts have said that no VAT is chargeable. But one aspect that needed to be considered was whether or not the non-charging of VAT would distort competition compared to the private operators. And the High Court decided that it needed clarification from the European Court on what was meant by would lead to significant distortions of competition.
So what has the ECJ said, and what implications does it have for the councils and their VAT claim?
Okay, well, there were three questions that the ECJ was asked to consider. One was what's meant by would, in the phrase would lead to, and what they said is that would means you need to assess not just actual competition but also the potential competition. You've got to look at new entrants or possible new entrants into the market. Probably the more important part of the decision relates to the term significant. The councils, and we advising the councils, said that significant is quite a high threshold, but the European Court decided that significant should be interpreted as meaning not negligible. So although there's still a hurdle for HM Revenue and Customs to get over, it's a lower hurdle than we'd anticipated.
So you basically wouldn't have to distort competition very much to fall foul of this?
That's absolutely right. But nonetheless, Revenue still has to demonstrate that there would be, a distortion of competition. Okay.
I mean, the other aspect of the judgment that I suppose that has been covered in certain places and might be confusing to people was the suggestion that there would be an activities-based test.
Yes.
What exactly is that? It's one of those things with ECJ judgments. You read them and you kind of think, not quite, as opposed to what? What does that mean for the councils?
Okay. The case that we were putting forward is that when looking at competition and distortions of competition, you have to identify the marketplace. And we've always said that the marketplace for car parking is the local authority's area, in that, if you want to fly from Gatwick, you don't park your car at Manchester. So, it makes, we thought, abundant sense to look at the local market. HMRC's view was that you had to look at car parking on a national basis, and that's been translated in EC speakers, the activity. And what they say is, well, look at the activity of car parking, and if car parking provided by public bodies distorts competition as opposed to the private sector, then it should be subject to tax. But the difficulty is, having said it's activities-based, they've given no guidance as to how you assess that activity, given the express statement that you cannot look at a local market.
Mm. I mean, a lot of people have said on the basis of that and also the significance element that HMRC would be quite pleased with the judgment. I mean, are you optimistic that when the case comes back before the High Court or the British, back to the UK courts, that you can win the case?
If we didn't think we could win, we'd be telling our clients that it's time to pack up shop and go home.
Yeah.
I think, notwithstanding HMRC's case is made simpler, we mustn't forget that the tribunal, when it looked at the four councils, said that they could find no evidence of any distortion of competition, let alone a negligible one.
Right.
So we're buoyed by that, and the question is whether the tribunal will say, okay, leaving aside the local market, on an activities national basis, is there distortion of competition? And if they can't find any distortion, then whether it's significant or otherwise,
Won't make a difference.
It won't make a difference.
Yeah. So when will it come back before the UK courts? What's the sort of rough timescale?
Difficult to say with any degree of accuracy. The High Court will need to reconvene, probably, and we would think we should see the High Court looking at this within the next 3 to 4 months, so before the end of the year.
Okay.
And our best guess is that they will then remit it to the VAT Tribunal with instructions to find the facts based on the new legal tests. And in terms of a tribunal hearing, probably around 12 months from now.
Okay. And I suppose the other aspect of the judgment, as with all tax cases, is what else will it affect? I mean, there's a suggestion that there are other activities that councils do where they might be going up against private sector competitors. What other sorts of things might this judgment impact on? I
think potentially it means that the revenue have got to reassess how they've treated a whole raft of services which local authorities provide, from youth centres, welfare, housing. Really, it's the whole panoply of local authorities' activities, because in each of those areas, increasingly, there is much more involvement of not just commercial providers, but also charities. And certainly charities could point to the fact that they are disadvantaged compared to a local authority, because charities can't recover their VAT and a local authority can. So really anything that a local authority does is potentially up for grabs.
Right, so, and potentially lots of money involved with a lot of these things as well.
Yes, there could be, and I think that HMRC may rue the day of having persuaded the High Court that it should go to Europe, because it's going to have to do some work now which I'm sure it hadn't anticipated previously.
To prove that there's some terrible distortion of competition in all these areas.
Or indeed, they may be forced to admit there's a distortion of competition, whereas before they'd be quite happy to accept there wasn't.
Yeah.
So they're going to have to apply a degree more rigour to their thinking and policy than hitherto has been the case.
OK, Mark, thanks very much. We'll watch that very closely. Thanks for joining us this week. We'll see you next week.